to the health and safety. So, welcome to the health and safety module. My name is David Wells. I've been doing this particular course for quite a while now. It is, I believe, the final module for your CPC. So we will be able to skip some sections, but it's fairly dense in terms of material. We will try our best to get through it quickly. If there are questions, please. Uh, I may not see raise your hand, but just you can definitely speak out during the call. And there will be a number of case studies presented in the module today. If you can please enter your information in the chat so we can discuss and just go through and make sure everyone is coming along with the case studies as well. So I work in the temporary employment agency world, and one of the benefits of this program, the CPC program, is it's taught by people within the industry. Uh, I'm sure having gone through all the other modules, you understand, you get a good sense of industry specific knowledge. Health and safety is a very specific thing where there's a lot of legislation and rules and regulations and so forth. And if you attend a generalized course in health and safety, you're not going to get the same sort of industry specific um, perspective on it. So I think this course today is very well received in terms of getting that sort of industry specific knowledge. So I'm going to go through. I will turn my camera off. I just find it distracting as we're going through. Um, but again, if you have any questions during the course of it, just by all means, please ask about them. Sorry, just one sec. Okay, obtaining your CPC certification. Um, Again, there is one more module added. Some of you may have taken the sales module. I've received some good feedback, at least from our team that have taken it. And you're going to be going through, I believe you probably already went through the mission statement, so I won't go through that as well with you. The code of ethics, same thing. You probably went through it with some of the other modules. One particular thing I'm going to draw your attention to is under the code of ethics, there's a section called workforce management. And it states we will address health and safety matters with clients, candidates, and employees, and will provide any personal training that may be required. We respect the right of candidates and employees to refuse work that could affect their health and safety and that of others. And so each one of us today are members of ACSESS. We pledge to uphold the code of ethics in our business dealings as well as our general business practices. And I thought I'd draw our attention to that one specific code of ethic term in terms of workforce management because it really applies to today's course today. We're going to have a number of learning objectives today. We're going to want to take a look at a number of areas. This is a very introductory course, but you will by no means be an expert of this course. By the end of it, you will have the requisite knowledge of basic health and safety. You will get all the information needed to write your CPC exam, as well as some information that hopefully you can take back to your own business and ensure that you're following the best practices as advised by ACSESS. So we're going to be looking at Occupational Health and Safety Acts. We're going to be looking at WHMIS, critical injuries, designated substances, first aid. We're going to be looking at some basic knowledge of injury and illness reporting. And lastly, we're going to commit to upholding all components of health and safety as it pertains to recruiters, employers, employees, candidates, and applicants, and assigned employees. And what we mean by this is, I think it follows along with our membership in ACSESS and adhering to the code of ethics. We're going to be looking at a number of topics, though. We're going to be looking at from a high level, but we are going to be delving into a lot of information today. And one thing I didn't tell us, right about the middle of the presentation today, we'll take a 5-minute break just to get up, stand, run to the washroom if you have to. But we will take that break probably about an hour and 15 minutes into the call today. Some of the topics we're going to be looking at today, safety principles and risk management. We're going to be looking at a lot of legislation. We're going to be talking about rights and responsibilities of managers, supervisors, and workers. We're going to be looking at hazard recognition and control measures, hazards and control measures for chemical, physical, and biological hazards. We're going to be discussing workplace inspections and accident investigations and developing and implementing effective workplace programs. The idea is upon the completion of the course, again, you're not going to be an expert on this. I've been doing this for almost 20 years, and every year, because rules change, or you have different pieces of legislation come in, or you have different court rulings, it is a subject where you have to constantly be on top of it, especially if you're operating across multiple provinces, as some of you may be. So the idea behind this, at the end of the course today, you will be able to find applicable occupational health and legislation and kind of understand what it means. You're going to know your health and safety responsibilities. You're going to be able to determine ways of meeting your occupational health and safety responsibilities. You're going to be able to identify some of the hazards associated with work in our industry and what it is you need to do to be compliant. You're going to take a leadership role in developing and implementing an occupational health and safety program, or coming back with some knowledge back to your own company and saying, you know what, I heard about this today. What are we doing about this? And it may just be you're not aware of it, or it may be, a gap in your specific business operations. All those things, I'm sure they are very good when they do happen, if you identify anything that you are missing. And then lastly, we're going to exercise due diligence, and we'll discuss due diligence a number of times over the course of today. Our first topic, we're going to be looking at the Occupational Health and Safety Act. And the idea is that employers, managers, supervisors, workers, and the government, we all have responsibilities when it comes to workplace health and safety. We all have different responsibilities, but we all have responsibilities and they all funnel into the overall occupational health and safety system. Workers have, additionally, they have rights to refuse unsafe work, participate in health and safety activities, and know about dangers in the workplace. We're going to be discussing responsibilities a number of times today and just how they apply to our industry. We're going to start with a case study. So let me remind you, if you can, I'm going to discuss the case study, ask a question. If you can please record your answer in the chat. We'll take about 30 seconds to provide an answer, and we will discuss afterwards. So in this specific case, we have a case study. It's from Saskatchewan in 2015. It involves an 18-year-old worker who's been on the job for 6 or 7 hours, fell at least 20 feet and broke his wrist and 2 vertebrae. He's been working on roof trusses that were 20 to 25 feet off the ground. He had not received any training, and there was no fall protection equipment provided. The customer tried to blame the worker's fall on his untied boots. The question is, pretend you had supplied this roofer, sorry. What are some of the steps that you would have taken to prevent this situation? You can look at what your own company does. You can look at any previous knowledge you have with health and safety, but just briefly, put in the chat section what you would do to prevent this situation. So the first answer, training on occupational health and safety, absolutely great answer. That is, and we will get into some of our responsibilities as temporary employment agencies, as employers in the workforce, and proper PPE. So two very good answers. One of the things we do have to understand is that this case study was presented because there are a lot of factors involved with it. If I take a look at this, the first thing I take a look at is the worker was an 18-year-old worker. And if you are operating in Ontario and some of the other provinces, they define that as a new or a young worker. And essentially what that means, the Ontario government views that as a subset of the working population who are either new to the workforce. So whether it be they've immigrated to Canada or they have not had previous jobs in the workplace, so they could be older, or they were young workers. And generally it's contained within about 18 to 25 years old for young workers. And each year the government of Ontario, they do what are called blitzes and go to workforces to discuss that. Because of that, we have different responsibilities with new and young workers. Essentially, how we train it is we want to ensure that because of their lack of experience and lack of previous knowledge about health and safety, we do want to take a little bit more time with these people. It is possible that this young worker did not know his responsibilities, did not know his rights under the Occupational Health and Safety Act, such as training and PPE that he should have been supplied with. The second factor here is the person fell over 20 feet in the air and they had not received any training or fall protection equipment provided. So one of the things that we know is work at heights requires training and it requires fall protection equipment or some combination of above, depending on the situation. It's apparent from this case study that this worker had neither one of those cases, had no training and had no actual equipment provided. Lastly, one of the things that we will discuss a couple of times today is workplace inspections. And one of the unique things about our industry is we are a third-party industry. We do not control the work sites where we supply the labor to. However, we still have a responsibility through law, through legislation, to protect our workers. And in a case like this, you would have to notify the government and say that there was a critical injury, and the government inspector would likely come out to the work site to look at it. One of the access pieces of advice for our industry is to provide what are called risk inspections, which we'll go through, or client inspections, or every company calls them something slightly different. But it's clear that this particular company did not actually perform any sort of risk analysis or inspection or client analysis of this site because they would have known there's no training, there was work at heights, there was no protection provided, and it is likely once we leave the course today and acquiring more knowledge, it is likely we would not have taken this customer on as a customer. And we'll kind of get through this more as we discuss everything. What is OSHA and regulations? So occupational health and safety legislation in Ontario outlines the general rights and responsibilities of the employer, the supervisor, and the worker. And it contains information on women's critical injury, designated substances, industrial establishments, and first aid. Overall, what it does is guide what policies and procedures, the baseline, what policies and procedures employers need to have within Canada. And Canada has 14 jurisdictions. We have one federal, 10 provincial, and 3 territorial, and each one have their own set of occupational health and safety pieces of legislation. Federal legislation is important, especially if you are supplying to one of your clients is federally regulated. And what does federally regulated mean? Approximately 10% of Canadian workforce falls under federal regulation. That includes airports, banks, ferries, tunnels and bridges, radio and TV broadcasting, cable systems, grain elevators, highway transport, pipelines, railways, shipping and shipping services, and telephone and telegram systems. The way I generally like to remember what may be federally regulated is if the work crosses provincial boundaries. So if you think about something like a truck driver, they may be driving from Nova Scotia to Saskatchewan. Thereby, they're actually crossing provincial boundaries. If you're supplying work in any of those areas that I just mentioned, and you're supplying new to this customer, you may want to ask them as part of your fact-finding information of the new customer whether or not they're federally regulated. And why is that important? You are required to administer health and safety rules to your employee based on what the customer is doing, essentially. So if they're federally regulated, your employee will be upheld to federal regulations. So it's very important that you understand if your customer is federally regulated or provincially regulated. OSHA aims to do a couple things. Ensure employees' health and safety and well-being in the workplace. Encourage employees participating in maintaining health and safety. Prevent risks to health and safety in the workplace. Involve employees through representation on committees. And to ensure expert advice and resources are available. Our role is to participate in health and safety meetings, committees, which ultimately are to provide education and awareness, onboard and train contract and temporary employees under their OSHA regulations. And that would be dependent on what territory you're in, if you're provincially or federally regulated or in a territory. Maintain and improve existing training opportunities and ensure on-site health and safety inspection reviews are done on a regular basis. We have a multiple choice here. So again, I'm going to read out the questions. Please answer them in the meeting chat. I complete a workplace safety site inspection with every new customer prior to sending an employee out on a work assignment. I do this A, all the time, B, about 90% of the time, C, usually around half the time, D, usually when they start working, I'll book time to go on site, or E, none of the time as my employee tells me whether it's safe or not. So please go ahead in the meeting chat and record your answer, whether it's A, B, C, D, or E. Does everyone know how to use the chat? So it's just up at the top. We're just going to record what our answer is. So we have a couple different answers. We got a C, so half the time, D, usually when they start working. I think if we're going to take a look at this and the general overall best practice of the industry is to do site inspections. And we want to be doing site inspections with new customers. So if we look back to that previous example where we sent an employee or the company sent an employee to work at a roofing place and there's no safety precautions, there's probably no health and safety whatsoever, that temporary employment agency would have been responsible for that accident. They did not do their due diligence to ensure that their customer was performing in a safe manner. And one of the an advice of ACSESS and a standard industry practice as advised by ACSESS is to perform client inspections. You would go into the client and just make sure that they are operating safely, that your employees are going to be provided with a good environment where they are not going to be injured on the job. And we do this for risk aversion. We do it to ensure that people aren't being injured. And we'll kind of look at costs later, like what workers' compensation costs are kind of like. So it's really important we do follow this as an overall goal of safety in our workplaces. So who's responsible for what? And I think we previously mentioned, we have a number of parties involved as being a third party provider of labor. We have workers, we have supervisors, we have the staffing agency, and we have the customer. And overlaid on top of that in the middle likely would be government. So you have your workers' compensation boards, you have compliance divisions like the Ministry of Labor here in Ontario. So who's responsible for what in this scenario? When it comes to health and safety of workers, everyone plays a key role in maintaining a safe work environment. And we accomplish that through training, through education, and through awareness. Now, our industry, again, is unique in that we have an additional layer of responsibilities overlaid in top of its general employment working relationship. We want to make sure it's very clear who is doing what in terms of protecting worker safety. And part of the reason we do site inspections, part of the reason we have, the suggestion is to put some occupational health and safety language in your contracts to be abundantly clear on who is providing what training is such that there is no ambiguity associated with it. We are confident that, if you have done a site inspection, you have in your commercial contract language that says, you know what, the customer is doing this training, the agency is doing this training. There's no ambiguity. So if there is a critical injury or somebody gets, deeply injured and there is a government inspection or there's police report or what have you, you can be reasonably confident that you've done what you are required to do if it's spelled out. So we got another multiple choice. Who advises workers of hazards in the workplace, their specific role, and provides written instruction where prescribed? Is it the customer, the worker, the staffing agency, or the supervisor? Please go ahead and put your answer. So a couple answers. We come back with the staffing agency. That's a bit of a trick question, actually. The correct answer is D, the supervisor. And the reason I say it's a trick question, because who is the supervisor? Is it a person at the staffing agency? Is it a person at the client? Is it both of those? And the answer is, it may surprise you. In terms of health and safety, you may be listed as a supervisor, even if you are a recruiter or a staffing coordinator, or you have some staffing responsibilities. If you are performing certain activities for that worker, such as assigning schedules and disciplining them and providing work instruction, you could be described as a supervisor under the Occupational Health and Safety Act. Your official role, your business card, if you have one, may not say supervisor, but under the eyes of the government, in terms of occupational health and safety, it is likely you'd be listed as a supervisor. So what does this mean for us? We're going to take a look at responsibilities, and we're going to start with responsibilities of our customers. Responsibilities of our customers, they have to ensure that the general workplace, so the equipment, materials, and protected devices are provided, maintained, and used in the workplace. They have to ensure there's a copy of OSHA posted in the workplace. They have to ensure that information, instruction, and supervision is provided to workers. Customer must assign a competent person when selecting a supervisor. The customer must have in place a written, annually reviewed health and safety policy, program, and have it posted and implemented in the workplace. And the customer has to take every precaution reasonable in all circumstances for the protection of workers. And number 6 is a very important point. What number 6 means is the government does not provide specific instructions on how to keep workers safe. They say that employers have to take every precaution reasonable. And they don't spell out what that means. You have to ensure that you're doing your due diligence as an employer. So if you are providing a service and you have employees on your premise, you have to ensure that you're taking every precaution reasonable. And generally what happens is that if someone is being charged by the government through a labor inspector or a Ministry of Labor, oftentimes when there's not a very specific thing, if someone gets injured, the charge is going to be specific to that. They did not take every precaution reasonable. It's kind of a catch-all statement, and it's one the government um, does specifically so that they're not actually limiting themselves to safety. The safety has to be borne by the employer, and in our case, by the temporary employment agency themselves as well. Taking a look at the responsibilities, we're going to look at the Joint Health and Safety Committee. They're specific to not just customers, but temporary employment agencies could be required to have a Joint Health and Safety Committee, depending on their size and how many employees they have in specific locations. In general, in Ontario, if you have over 20 in a specific location, you are going to need to have a Joint Health and Safety Committee. And what does the committee do? Well, they take a look at hazards in the workplace. They identify them, they evaluate them, they participate in the programs, they help devise the programs, they help review the programs and ensure that the overall health and safety management system is functioning. They get involved with employee complaints, suggestions concerning health and safety. They are involved with injury and work hazard records. They may not be ultimately responsible, but they do review when things of those natures happen. They monitor and follow up hazard reports and recommended action, participate in health safety inquiries and investigations, participate in resolving workplace refusals or work stoppages, which we will discuss in a future slide. One of the more important things, they make recommendations to management for incident prevention and safety program activities. And that's one of the most important one. If you want to drill down what the ultimate responsibility and benefit of a Joint Health and Safety Committee is, It is taking the information from the actual workplace and having an official mechanism to supply to management to say, you know what, this isn't working, this machine is unsafe, we've noticed injuries or we've received complaints about it, and providing those recommendations to management. And lastly, they monitor the effectiveness of these programs. What are the responsibilities of the workplace supervisor? Supervisor ensures that workers abide by the act and regulations and wear prescribed PPE equipment and clothing. That means if a hard hat is required on the worksite because the employer says so, the supervisor is the one for ensuring that that hard hat is worn and is worn all the time. Supervisor advises workers of hazards in the workplace and their role and provides written instruction where required. And lastly, we discussed this in the previous slide, the worker takes every precaution reasonable in the circumstances for the protection of the worker. That's that general overall umbrella statement. Supervisors are required to be the spearhead of that involvement. Lastly, what are the responsibilities of the agency? That would be us. You're going to notice a lot of similarities. We need to provide required training to all workers under OSHA and provincial compensation acts. We need to ensure that protective devices were provided by the agency or worker, such as work boots, eye protection, are maintained and used as prescribed in the workplace. We have to ensure that workers abide by the act and regulations and wear the prescribed PPE equipment and clothing. So very similar to what a supervisor's responsibilities are. And we kind of liken that back to under OSHA, that that designation of supervisor is a little more expanded, especially in our industry. And lastly, we need to ensure a copy of OSHA is present in the workplace. We're going to take a look at rights, switch gears a little bit. We're going to be taking a look at the rights of workers. So there's three of them, and we will discuss. So all workers, and by workers, occupational health and safety designates workers as pretty far-reaching. It includes temporary workers, part-time workers, contract workers. Sometimes it could even include like vendors coming in, so like a plumber or something. It's very far-reaching the way OSHA labels workers in the system. Everyone has the same basic rights, these three rights: right to know, right to participate, and right to refuse unsafe work. So use of appropriate communication for all employees needs to be met. So that's very important for a community like Canada, where we do have different languages. So we do have two official languages. So depending on your workplace, you may be required to have both forms of communication, as well if you have a predominant set of workers from a specific country that have a specific language. In terms of safety, you may want to consider having all the safety rules at least be available in a different language. We're going to take a look at the right to refuse unsafe work later. And that's an important one because it's truly one of the foundations of it. But the right to know, what that means is you have a right to know what hazards are present in the workplace. The right to be given the information, training, and supervision you need to protect yourself. And in our industry, one of the ways I teach that within my own company is if you take a look at a food industry. So if you're supplying workers to a food manufacturer, food plant, or packaging, or someone that is dealing with food, and you know that it's a peanut, they have peanuts within their manufacturing process somewhere. You want to ensure that you're supplying that information to any sort of new temporary staff you are sending to that customer. Many of us do know it's becoming way more prevalent now than it used to be, but many of us know people that are allergic to peanuts. That allergy could be, depending on the person, could be quite severe. It could actually ultimately lead to death. So one of the things I like to explain to, especially new staff within our company, is to say, you would have to ensure that you're explaining that hazard, that known hazard. There's peanuts in the manufacturing process to each new person you're sending there. Same could be said if there's very heavy lifting. You would want to explain that hazard to people because you would automatically remove some people from being able to do that type of work. So it's very important that employees have that right to know about what hazards are in the workplace, especially in our industry where we are supplying workers to different workplaces. The right to participate discusses your right to participate generally in a joint health and safety committee, which we discussed in the previous slide. You have the right to be an active member in the health and safety of the workplace, typically through the joint health and safety process. And lastly, you have the right to refuse unsafe work. That right is, again, born on every level of employee out there. If you believe that the work is unsafe, you have a legal right to say, I believe this is unsafe. I believe if I continue working in this particular machine or area or workplace, that I will be injured, and I am calling attention to it. And there's certain processes that need to happen if that occurs. We have another multiple choice. When should you do a site-specific hazard safety assessment at a new customer? Prior to the assignment starting, within the first 48 hours of the assignment starting, prior to the assignment starting, or if new hazards have been introduced to a worksite. D, prior to the assignment starting, or repeated when conditions at the worksite changes. C, or lastly, answer F, which includes the answers A, C, and D. So when should you do a site-specific or client risk inspection? Any answers? So right now we have the answer F. So we should do it prior to the assignment starting. Agreed. Good answer. Prior to the assignment starting or if new hazards have been introduced. Also agree with that. And D, prior to the assignment starting, repeated if conditions at the worksite changes. So those that answered F, that is the best answer here. Any of those conditions occur, you should be doing a site inspection. So you do it before you engage in work at this new client. Let's say the client introduces a new machine or new operation in their facility. You want to go take a look at it, especially if you are supplying labor in that area. Um, and also repeated when conditions of the worksite changes. So if they introduce like a whole new process, they change the operation of the machines, let's say, or you're supplying, let's say you're just supplying work in the administrative in the offices, and now you're supplying, let's say, a forklift driver. You may not have seen the actual back of the location where the shipping department is. You want to go take a look at that and just make sure it's as safe as you're comfortable in your company with providing. I'm going to switch gears a little bit and start talking about WMIS, uh, officially known as WMIS 2015, the Global Harmonized System. What do you need to know about WMIS? We're going to briefly go through the history of WMIS. We're going to be looking at product classifications, hazard identifications, labeling requirements, SDSs, exposure to hazardous materials. We're going to be looking at the difference between provincial and federal regulations, and lastly, worker rights. WMIS is what's called as a right to know legislation. It applies to specifically hazardous products. There are several pieces of legislation that are kind of cobbled together that's effectively called WMIS. It's a comprehensive plan for providing information on hazardous materials intended for use in workplaces. WMIS applies in all Canadian workplaces, which are covered by occupational health and safety legislation, and where WMIS controlled products are used. So if you're not using any WMIS products whatsoever, you don't need to have a WMIS program. Very rare to have an an employment work site that doesn't use some sort of WMIS covered material, though. Compliance is critical, and therefore knowledge is essential for you, your workers, and your customers. I typically find that our industry does pretty well from everything I've seen with regards to WMIS. I'm sure each one of you, if you think about your processes at your workplace, you probably have some sort of WMIS training. Hopefully, you have a WMIS test, a knowledge-based test to make sure that they understand what you are training on. You might have a video or some sort of online webinar. And that's well and good. And that is one component of WMIS. There's another component called the practical aspect of it when you're actually dealing with the substances themselves. And usually the access advice is to, generally we do the information session, which we'll go through today. And usually we offload the responsibility for the specific products to the customer. And the reason being is we can't be knowledgeable on every product the customer is using. We would offload that responsibility to the customer. And hopefully, again, when we discuss the commercial contracts, you'd probably want to make sure that's a component of your commercial contract to say, you know what, Mr. or Mrs. Customer, you're responsible for training on the safe operation, the PPE required, and how to use that substance in the workplace. So looking at the history of WHMIS is not a very old piece of legislation. It was basically started in 1979. And what happened was we had an increase of situations where we were using more substances, more chemicals, and so forth. And we're really starting to demand safe workplaces. And part of it's from unions, and part of it's from government, and part of it's employers themselves. And what happened is these three groups kind of came together and said, you know what, we should start looking at this. And then, like a lot of things that happen in the world, a critical event happened. And that critical event was in November of 1979. There was it's called the Mississauga train derailment. And essentially what that produced was an explosion and release of toxic gas that caused the evacuation of 200,000 people. It's a very major event. Mississauga was obviously not as big as it is now, for any of you in Ontario, but to cause the disruption to 200,000 people that had to be evacuated, that was a national event. And that kind of um, caused WHMIS to become more important. 1980 had the introduction of the Transportation of Dangerous Goods Act. The government and labor and employers and unions cobbled together a working group. And the introduction of in 1980, the WHMIS report of the Project Steering Committee. And essentially, that is the start of WHMIS as we know it. 1988, the execution of WHMIS on a national basis occurred. 2015, they introduced a new version of WHMIS, which we will discuss, and that was required to be implemented by the vast majority of employer groups by 2018. So, what's the intent of the global harmonized system? The idea is we understood that we lived in a world where it's a little bit smaller than it used to be. Whether you call it a global marketplace, whether we are getting products from all over the world and they're coming into our country, we're sending products to other countries, and that is kind of the way the world is working now. Through market demands and so forth. So we recognized that as essentially a world group to say we're concerned about the health and safety of our people. We want to, as best we can, try to consolidate this program into a workable situation where it's similar across the world. And the idea is we want to facilitate trade. We understand that the multiple classification systems was not working. So if you have one system in Canada and one system in Japan, that didn't quite work. And again, in 2018, we came to the global harmonized system. And this example here is there's a chemical that was in place. And if you take a look at the classification, so it was listed as toxic in Canada, US, Japan, and Korea. In the EU, Australia, Malaysia, and Thailand, it was listed as harmful. China listed the exact same chemical as moderately toxic. New Zealand labeled it as hazardous, and India labeled the exact same chemical as non-toxic. So the chemical itself didn't change. The people operating it, the hazards associated with it, all the same. Same in Canada as it was in India. But because the system didn't align with themselves, didn't align with other countries rather, you weren't getting good information. And we recognized that we had to change that. I'm not going to discuss the areas for change so much just because we'll discuss exactly what they are now. One of the first components of WHMIS 2015 was the move to pictograms, which they called these graphic images. They immediately show the user a hazardous product, what type of hazard is present. With a very quick glance, you can see, for example, that the product is flammable or that it might be a health hazard. And most pictograms have a distinctive red square set on one of its points border. So you have this diamond shaped. For the most part, most of them have this sort of thing where you can look at it and recognize this product has specific requirements. Inside the border is a symbol that represents the potential hazard, fire, health, corrosive. Together, the symbol and the border are referred to as a pictogram. And pictograms are assigned to specific hazard classes or categories, which we will discuss in a moment. One of the great things with the pictograms is you don't necessarily have to know the language of the country you're working in or having a very good command of that language. So the exploding bomb tends to look like an exploding bomb. Flammable for flame rather looks like a flame. Gas cylinders, you don't even have to know the language. You can understand that that's a gas cylinder. And so that's one of the good points of it. Even if you are new to the country, so you recently immigrated to Canada, with very basic education, with a very quick sort of primer on the system, you're going to understand, oh, wait, this is hazardous. I know I need to do something, or I need to wear specific PPE. I should go talk to my supervisor if I don't know how to use it. So the idea was simplification and unification across the globe. So we discussed hazard groups. There's two different hazard groups. There's physical hazard groups. So that's based on the physical or chemical properties of the product. So it's flammable, it's reactive, it's corrosive. And then you have the health hazards, and that's what the product causes. So the health effect on the person themselves, or the like how it affects them. So it could be things like eye irritation, respiratory issues, asthma symptoms, breathing difficulties if inhaled. Could be carcinogenic, so may cause cancer. And we have some examples here of the physical hazards, so flammable gases, flammable aerosols, oxidizing gases. And you have what some health classes of the health hazards be, so acute toxicity, skin corrosion, and so forth. Hazard classes are a way of grouping together products that have similar properties. So most of the hazard classes are common to GHS and will be used worldwide by all countries that have adopted GHS. And again, that was in 2018, so should be well established. So we have another question here. So labeling. We're going to be talking about WHMIS labeling. Labeling materials is a way health hazard information is made available to users. And although it is not required by law, it is recommended that all health or all hazard materials be labeled. True or false? So this is another one of these tricky questions. So if you take a look at it, it sounds like it should be true. So those that answer true, I understand why you answered that way. A little trick here though is where it says, although it is not required by law. So labeling, which we will discuss in the next couple slides, labeling is a required component of the WMS program. Labels, they're important because they are the first alert that there may be hazards associated with using the product covered by WMS legislation. And we'll get into what the labels look like. I'll show you exactly what a standard generic label may look like. It has the program, it has the pictograms and so forth. And the benefit of them is it tells what precautions to take when using the product. Labels may inform the person there's a safety data sheet available, which contains more detailed information. I'll explain what that means in a moment, but labeling is required under the WMIS program. One more multiple choice. What is the purpose of labeling? This is not a trick question. This one is self-explanatory. So there's no tricks in this one. So what do labels do? Labels tell what precautions to take when using. Labels are required under government regulations. You can relabel at any time when there's a change in substance. D, it tells you that there is additional information on the SDS, all of the above, or A, B, and D. Go ahead and record your answer, please. So very good. Everyone's answered F so far. So yeah, labels tell what precautions to take when using. Agreed. Labels are required under government regulations. Also agreed. And it tells you there is additional information on the SDS. So those are the three important points with this question. So there are two different kinds of labels. We'll discuss the first one, this being the labels of the supplier. So in Canada, we have two official languages. The language must be in English and in French. You have a product identifier section that has to be on the label. So that's the brand name, the chemical name, the common name, or the generic name. So what is the name of the product? You have the initial supplier identifier. So that's the name, address, telephone number of either the manufacturer of the product or the Canadian importer. So there's two ultimate people responsible, either the Canadian company that made that product or the Canadian company that brought that product in from another country. Those have to be identified on the label of the supplier. Has to have the pictograms, which we went a couple slides ago we discussed. Has to have signal words. So either danger or warning. Danger is used for high risk hazards, while warning is used for less severe hazards. It kind of makes sense. You're going to have a hazard statement, which are standardized phrases which describe the nature of the hazard imposed by the hazardous product. You're going to have what's called precautionary statements, standardized phrases that describe measures to be taken to minimize or prevent adverse effects resulting from exposure to the product or resulting from improper handling, storage of the hazardous product. And lastly, you're going to have supplemental label information. The labels can be used for precautionary actions, hazards not yet included in the GHS, physical state, or route of exposure. This is an example of what a supplier label could look like. The program itself doesn't say it doesn't have to have any specific aesthetic, or it doesn't have to look a certain way. It doesn't tell you what font to use or any of those other natures. Um, it has to have these key components though. So you have the product identifier. What is the product? We have language in both English and French. We have our pictograms. We have the signal words. So in this case, it's hazard. We have a hazard statement. Fatal if swallowed causes skin irritation. Precautionary statements. So discussing the PPE of it, wear protective gloves, wash hands thoroughly after handling. You got to store it locked up. And lastly, we have the supplier or the distributor listed at the bottom here. So was it two, four, six? All seven components of the supplier label are on the label. Again, it may look slightly different, but it has to have these components. Looking next, what a workplace label is. So it's not as robust as the supplier label. It has to have the product name, has to have some safe handling precautions. It may include pictograms or it may not. Any other supplier label information. And there has to be a reference to the SDS if available. So safety data sheet available. Similar to the supplier label, there's no requirement for how it looks. A workplace label is required when a hazardous product is produced or made at the workplace and used in that workplace. So if the manufacturer is also the company, they don't have to put a supplier label on. They can just use a workplace label if they're using it inside that work site. Anytime a hazardous product is decanted, so if it's transferred from, say, a larger barrel into a smaller, more manageable, like a spray bottle, let's say, you need to know what product is in that spray bottle. So you would apply a supplier label, or sorry, a workplace label to that product. And lastly, a supplier label becomes lost or illegible, unreadable. So if you can no longer read it, if it's no longer, again, if you can't identify what the product is, good time to put a new label on there. Discussing the hazard statement, again, a component of the supplier label. Each hazard class and category has an assigned hazard statement. Hazard statements are brief, standardized sentences that tell you more about the exact hazard of the product. So some quick examples, extremely flammable gas. You know, you can conceptualize what that means. Fatal if inhaled, causes eye irritation, may cause cancer. The statements are short, but they describe the most significant hazards of the product. The wording of the hazard statement helps to describe the degree of the hazard. For example, may cause cancer is more hazardous than suspected of causing cancer. So they give the user some idea of what the hazards of working with that chemical are. Another multiple choice question. What does SDS stand for under WMIS 2015? Safety data sheets, safety directive sheets, safety decree sheets, safely dictate sheets. Very quick answers. Safety data sheets. Perfect answer. Um, Talked about SDS sheets as required. What does an SDS sheet stand for? Safety data sheet is a document that contains information on the potential hazards, health, fire, reactivity, environmental, and how to safely work with the chemical product. In Canada, every material that is controlled by WHMIS must have an accompanying SDS sheet that is specific to each individual product or material. It's important to make the distinction that SDS sheets are prepared by the supplier or the manufacturer of the material and not the workplace. So again, that's whoever created it in Canada or whoever imported it. It's intended to tell what the hazards of the product are, how to use the product safely, and what to expect if the recommendations are not followed, what to do if accidents occur, how to recognize symptoms of overexposure, and what to do if incidents occur. SDS sheets are an essential starting point for the development of a complete health and safety program involving WHMIS. So SDS sheets are actually, they go far past what a label needs to needs to present. So the supplier label or the workplace label, it provides a lot more information. They're usually multiple pages, very small font. They tell you a lot of information regarding the chemical itself. So you need information like the SDS sheet if there is, let's say, an exposure incident or someone is the chemical spills on them. You can take a look at the label, but there's going to be much more information on the SDS sheets. What is the Women's Worker Education Program? What does that entail? So education programs, and we're kind of going through it today. They include labels, they include information on SDS sheets, hazard information, the handling, storage, disposal, presence of hazard materials, and emergency procedures. So the law requires that the employer educate a worker exposed or likely to be exposed to a controlled product. An exposed worker is any worker who stores, handles, uses, or disposes of a controlled product, or who supervises. And that's an important aspect. You don't have to necessarily work with it, but if you're supervising workers who work with it, you have to be trained on it. One of the questions a lot of people ask is after a worker has completed the education program, is there any follow-up or testing required? You want to have within your own system. So if you have a worker that works for you long enough, even though they're temporary, you want to have a retraining system in place. And generally that retraining should be done yearly. What are the employee responsibilities with respect to MS? Workers must participate in the education and training sessions. So if the employer is responsible to administer WMIS education, employees themselves have to attend the education. They have to follow the safe work procedures. So whatever the employer tells them to do with regards to the product or the chemical or what have you, they must follow the safety processes. And that includes our temporary workers. So if you're supplying to the customer and the customer has specific education on how to use the products, they are responsible to do so. Employees should work in compliance to the Act and regulations where prescribed PPE equipment and clothing and report any hazardous machine defects or any contraventions to the supervisor. So all those, if you remember the responsibilities of the supervisor, all those are the responsibilities of the supervisor. So it is about the halfway point of the course today. We're going to take a 5-minute break. It's 1:55, at least my time. We're going to be back at 2 o'clock. So get up, go to the washroom, whatever you need to do, and we'll be back at 2 o'clock. Okay? The course today, so we're well on our way. It's going pretty quick today. We're going to switch gears now and start talking about hazards. And hazards are something that can be found in every workplace. They come from a wide range of sources. And we're going to be taking a look at some of the more common workplace hazards, along with some direction on how to either eliminate them or control them. Maybe starting it off with a case study. This is a bit of a longer case study, but we will discuss it, at least the salient points of it. And the idea was that 3 workers were working on an asbestos abatement project at a single family home. The abatement area was enclosed. In that area, certain asbestos containing materials had been removed, and there was an asbestos dust hazard present. Ministry of Labor inspector attended and conducted an inspection. The inspector found one of the workers exited the enclosed area wearing street clothing. Two other workers were found inside the enclosed area not wearing protective clothing. One was performing deep cleanup, and the other was securing bags with asbestos-containing materials. The company pleaded guilty to having to ensure that only persons wearing protective clothing and equipment enter a work area that is an asbestos dust hazard. The company was fined 25,000. And lastly, the supervisor was fined 4,000 after pleading guilty to failing to ensure workers use protective clothing and equipment. So this one, I'll just discuss the important points of it. First off, asbestos is a material that's used in the workplace, or it used to be used a lot more in the workplace. Still is found. We'll kind of get into the specifics of asbestos in a minute, but asbestos has no safe working limits. So the government doesn't even say you can work around X milliliters of asbestos. The reason is some people get sick from it very easily. They could be exposed to a very relatively small amount of it, and therefore, because it is so hazardous and potentially hazardous, there are some very specific rules and regulations associated with working with asbestos. Why we bring that up? This is a good case study because it shows a couple things. One, that the client here, who was doing asbestos abatement, so they were removing asbestos and securing it, they weren't following the rules. So they weren't following the regulations, whether they were doing that on purpose or they just didn't know any better. Doesn't really matter. The law doesn't care that you don't know what the law is. The law still, you're still responsible to abide by it. Essentially, the biggest faults of it was there's no PPE worn, so you need specific like clothing to wear over your street clothing. And the idea of it was because if you're wearing street clothing or just your regular clothing, you can actually bring it off the work site, bring it into your house, bring it into your home, expose your family, your children, so forth, if you have them. And therefore, there are very specific things associated with asbestos. I bring this up because if you receive a call from a client that says they want you to work on an asbestos abatement project, or there may be asbestos involved, you're going to want to ask some questions. You're going to want to ask what they're doing, what their processes are, ensure that they are operating safely. And asbestos has different rules and regulations depending on what province you operate in. Ontario has very specific rules. There's, again, the clothing is required. You have to have means of containing it so that there is essentially negative pressure. They have filters and so forth that lessen the amount in the air. There is the destruction of the asbestos are very specific things. Every province has its own set of rules, but essentially every province recognizes that asbestos is very harmful, and workers exposed to it oftentimes have very severe and significant health effects later in life. So what are some designated substances? The designated substances are defined by OSHA, and this is a very Ontario thing. So Ontario specifies what designated substances are this way. It could be a biological agent, a chemical agent, a physical agent, or any combination of the above. These substances or hazards can be hidden in our workplace, our homes, our schools, and even products we use. Some workers encounter hazardous substances by surprise when performing fairly routine tasks. To protect workers from the kind of unexpected exposure, regulations have been made under the Occupational Health and Safety Act. So designated substances are, right now in Ontario, they're listed as these 11 things. It's listed as Regulation 4909, designated substances, identifies the requirements if these substances are present in the workplace. The employer must review the work methods and assess the likelihood of worker exposure. When there is likelihood of a worker exposure, a control program must be instituted that includes engineering controls, work practices, hygiene practices, record keeping, and medical surveillance if applicable. You have to consult with the Joint Health and Safety Committee. They have to be involved with the program. Ultimately, what this means is when a designated substance is present in the workplace, whether you're using it, the chemical or the product, within the everyday procedures of your company, whether it could be present because you are, let's say, doing demolition, whether it is a byproduct of a product you are using or process you are doing. All those things dictate that the substance is in the workplace, and then this program has to be implemented. So then you need the supervisor involved to conduct the assessment, and the assessment being the information on use, handling, storage, and disposal, actual and potential exposure of workers to the substance. So perhaps it's just in one area, so the actual exposure may be limited to only a few workers, and methods and procedures required to control that exposure. So we'll take a look at some of these designated substances. Number one is used primarily as a starting monomer in the manufacturing of synthetic polymers such as acrylic fabrics found in carpets. Arsenic is a strong poison. It's typically used in wood preservatives, insecticides, and herbicides. Arsenic is also used in alloys of copper and lead. Asbestos, which we discussed, asbestos. One of the things with asbestos is it was viewed as essentially, the wonder chemical of pre-1970s. It was used in a lot of things. So insulation, wallboard, asphalt, adhesives, caulking, ceiling, floor tiles, gaskets, drywall compound, plaster, and roofing shingles. So essentially almost every piece of construction thing that we used to build houses and build institutions and so forth. If the work site, let's say you have a client calling you and you're doing demolition on a work site that's from 1950, good chance that there's going to be asbestos involved somewhere on that work site. Again, it's a question you will want to ask your clients. Doesn't mean it's necessarily bad. It just means that there are certain precautions that need to be taken. Benzene is generally used to make other chemicals, which are then used to make plastic, resin, nylon, rubber, lubricants, detergents, drugs, and pesticides. So again, basically everything we create right now, everything we use is benzene is probably involved somewhere in the process. Ethylene oxide is involved in the manufacture of ethylene glycol, surfactants, fumigants, fungicides, and petroleum demulsifiers. Coke oven emissions are the airborne constituents of the byproduct created by destruction distillation of coal and petroleum. So essentially, when you're burning coal or petroleum, you're going to get these emissions. Isocyanates, typically found in spray foam insulation, sealants, finishes, paint, and auto body materials. Lead is generally found in old paint. So again, if you're doing any sort of restoration type work, old mortar, old water pipes, lead sheeting, and contaminated soil. Mercury is typically found in fluorescent lights, switches, pressure gauges, electrodes, and contaminated soil, silica, bricks and blocks, granite, abrasives, concrete, sandstone, cement, and mortar. Again, generally, if it's in the bricks and the blocks by themselves, it's not an issue. As soon as you start cutting rocks, bricks, cement, silica is airborne, which becomes much more of a hazard because you're breathing it in at that point. And lastly, vinyl chloride is typically used in the manufacture of PVC, which is used in furniture, upholstery, and many plastic products, including plastic pipes, wire, and cable coating. So none of these items is on the test itself for the CPC exam. What it should be, though, is a trigger for you to have something in your process where if you're dealing with a new customer, you're asking the question, do you use any designated substances? And if the customer says yes, then you want to ask a few more questions, like what their process is. Do they have a supervisor assessment? Are your employees going to be involved? Or like who is going to be involved with this? Again, it does not necessarily mean you're not going to want to do business with them. You are going to want to ask some more questions though, and make sure that the customer, the potential client, is operating safely and in accordance with the law. You don't want to be sending workers into work sites where they are operating with designated substances and the client themselves are not operating within the confines of the law. Taking a look at some other hazards in the workplace. Confined spaces. Confined spaces, they can include a number of things. So they can be silos or vats, tanks, sewers, pipes, access shafts, truck or rail cars, manholes, manure pits, storage bins, ditches and trenches may also be confined space. Essentially, a confined space is any area where human beings shouldn't be normally situated. So if you think about the easiest one is like a truck or a rail car. So you see like a milk truck, let's say, or a milk rail car or gas or what have you. Think about it that way. Humans aren't supposed to be in there. Generally, they're used for transporting substances. Usually there's a limited means of getting in or out. So there's probably just one hatchway and maybe a valve to drain it. Um, this is one of those things where the potential for human hazards is very high. And so the legislators through OSHA look at that and say, for any confined space work, you have to have some very specific rules in place. And I bring this to your attention because oftentimes our industry does get asked to supply labor for confined spaces. And depending on what province you operate in, those can be very significant. They can be, you may have to have a plan in place to extricate someone, so to pull someone out from a confined space. If they pass out, you may have to have air monitoring. In Ontario, you would have to have air monitoring. You would have to have plans set up in place. So if you were asked to supply this kind of labor, you want to make sure that the customer is operating incredibly safely and within the confines of the law. Another hazard, indoor air quality. Common issues associated with indoor air quality include improper and adequately maintained heating and ventilation systems. Could be contamination by construction materials, glues, fiberglass particle boards, chemicals, paint, mold, for example. Increasing the number of building occupants and time spent indoors. Indoor air quality problems may arise from the indoor environment themselves. So the temperature could be inadequate, could be too high of humidity or too low. Lighting could be too high or too low. Could be excessive noise. Could be contaminants such as chemicals, dust, molds, fungi, bacteria, gases, vapors, or odors. And this is very important if you are working within an indoor environment. If you're supplying administrative staff, let's say, and there's mold in the workplace, you could be held liable for those sort of problems. So it is very much something you want to be aware of. And this is where these site inspections are really important. If you go into a client and it, smells like sewage, let's say, because they constantly have a backed up sewer, you may have some people that are able to function fine in that work environment. You may have some people that have some very serious health effects from it. Third, we have lasers. So as laser beams, they are used in a number of situations. They could be used in terms of medical procedures. They could be used to burn things. They could be used to cut things. They could be used to simply scan UPC codes. The hazards associated with laser beams, they could be from the fumes from actually burning something or cutting things. They could be associated with the actual light themselves. So if you have like a laser beam shining in someone's eye, depending on the strength and so forth of the laser beam, you could have a very serious health effect for that person. Again, one of those things that you do want to make sure if these hazards are in the workplace, you identify them and then you understand, are my employees going to be exposed to it and what sort of precautions do they need to take to be safe? Scents and temperatures are, a little more prevalent. Scents, especially. For a long time, we had, scent-free workplaces. We still have them. A lot of places try to do that, but essentially those are very hard to control. And scents can be the smells or odors from generally cosmetics or the person or products they're using. And scents can have very adverse health effects, including headaches, dizziness, and nausea. And what could be, again, this is sometimes different people have different exposure limit levels to scents. A person could smell someone wearing perfume and have no effect whatsoever. Some people may like that. Some people may have one of those strong adverse effects, including nausea, headaches, or even worse, depending on what's in the scent. Temperature is something that is, um, it's not just a nuisance. So if you're working in an office and it's quite cold and you have to wear a sweater, that's one thing. Temperature can also be a very significant hazard in the case of if you are working outside. So we're in Canada, we're just getting out of winter. We all understand there are you need to wear specific clothing to deal with the Canadian winter. We also know that Canadian summer can be incredibly hot. You're dealing with sun, you're dealing with heat, you're dealing with so forth. And temperature is one of the things where There's no specific to high temperature. So the Occupational Health and Safety Act doesn't say, you know what, after 24 degrees Celsius, you have to take necessary precautions. It is more specific to lower temperature. And the reason being is you can have some very specific issues associated with low temperature, such as hypothermia, frostbite. And you'd have to be very sensitive to that if you have workers, for example, say a forklift worker who's operating in a freezer environment. So they're coming in and out of cold storage. There may be very specific things that they should have available to them, such as a jacket and a hat, some sort of like e- ear protection, let's say, to deal with that. So again, be sensitive to that. If you are supplying to these sort of things, keep these in mind. Keep scents and temperatures as one of your components for inspections. Ventilation is the mechanical system in a building that brings in fresh outdoor air and removes the contaminated indoor air. In workplace ventilation, it's used to control exposure to airborne contaminants, um, including fumes, dust, and vapors. Especially if you're working in a manufacturing environment, you're going to have like exhaust fans that are taking it out and bringing fresh air in. As we came out of COVID, I'm still here, but um, all of us became very sensitive to ventilation. There was the talk of having um, um, air refreshers in the workplace and um, scrubbing the air from those sort of contaminants. Very much a hazard, and depending on the workplace itself, it is it could be the difference between a worker getting injured or not. Weather, we kind of discussed that during temperature. So the weather, not only hot and cold, but you have to be concerned with lightning, let's say, or if they're working in the dark, or if they are working if you're working on the East Coast and you have the ocean, um, East or West Coast rather, if the ocean is being impacted by weather and winds and so forth. Again, all these things are hazards. You do want to consider them. Working alone is an interesting one. Some provinces have specific working alone legislation associated with health and safety. Some provinces just include it more in the general duty clause to protect workers. And the best way to describe the hazards of working alone, I always found was if you consider the gas station attendant, so someone working at a gas station facility, it's the general place where people go and fill up their cars. A lot of times they're open late at night. A lot of times it's just one person operating, like, especially at night. And you have some very specific hazards when you are working alone. Especially in this case, my example, you have people dealing with money. You have some high value products, whether it's confectionery items or in Ontario now we have beer in these sort of workplaces. You have lottery and nicotine and so forth. You're dealing with people. All of these are strong red flags for working alone. And so it's not necessarily that people can't work alone. It's that the employer has to take reasonable precautions to protect that employee. So if you think about the gas station example, some of them do not allow customers to come in at night. They may have bars in the system, and you have to pay for it either at the pump or through a window. They may have glass to protect the high value items, also protect the person from the general public. So it's again, it's not so much that working alone is the hazard itself, but it can lead to other hazards just by it's being parallel to these other more threatening sort of issues. We're going to be looking at some specific hazards and some specific cause. I'm going to start with workplace harassment. And workplace harassment, as defined in Ontario, but most provinces have a very similar sort of context associated with it. Engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably to be known to be unwelcome, or workplace sexual harassment. It is our role as employers to ensure that workers are safe and healthy in the workplace. Both agency and customers will have a policy and program into place to support this sort of context. Started with Bill 168, it was called probably 15 years ago. And this is where the programs kind of started out, where they started carving out workplace harassment and violence, which we'll get into in a second. And they specified some very specific things with regards to violence and harassment. So harassment can be anything that's unwelcome to the person. It could be words, it could be actions, um, and they could be known or should be known to be offensive or embarrassing. So it doesn't necessarily mean that the person is intending to be offensive or embarrassing or humiliating or demeaning. It's that the receiver of that deems it such. Some of these things for harassment, workplace harassment, they could include making remarks, could be jokes, innuendos that demean, ridicule, intimidate, or offend. It could be displaying or circulating offensive pictures or materials in print or electronic form, including email, group chats, anything of that nature. Doesn't necessarily have to occur during working hours. It could be after working hours as well. Could be include bullying, repeated offensive or intimidating phone calls or emails, or lastly, workplace sexual harassment. So what isn't workplace harassment? Luckily, the government recognized that some people are going to view harassment differently, and they carved it out and said that workplace harassment is not a reasonable action taken by an employer or supervisor relating to the management and direction of workers in the workplace. So telling an employee who has to make 60 widgets an hour and they're only doing 30 that they have to improve their performance, that's not harassment. You're enforcing the procedures and policy of the workplace. Reasonable management actions would be part of a manager's or supervisor's normal work functions and include changes in work assignments. So, moving them from one machine to the next, change in scheduling, job assessment and evaluation. So any sort of performance review, workplace inspections, implementations of health and safety, and disciplinary actions. None of those things are generally viewed as workplace harassment. So, for example, if a worker was not scheduled for shifts solely because of his or her sexual orientation, this would likely be workplace harassment. If they were not scheduled for shifts for something not related to that, that would not be workplace harassment. Oops. Workplace sexual harassment has its own section, and it means engaging in a course of vexatious comment or conduct against a worker in the workplace because of sex, sexual orientation, gender identity, or gender expression, where in the course of comment or conduct is known or ought reasonably to be known to be unwelcome, or making a sexual solicitation or advance where the person making the advance is in a position to confer, grant, or deny a benefit or advancement to the worker. So this is a power dynamic. So a supervisor requiring certain things from an employee. Now, workplace sexual harassment, um, maybe you if you watch older movies, let's say, you may see this a little bit more. We recognize that it's an unwelcome action in the workplace. It is completely unwelcome, and we have put this into place by law. And what it means is you cannot involve unwelcome words or actions associated with sex, sexual orientation, or gender that are known or should be known to be offensive, embarrassing, humiliating, or demeaning to a worker or group of workers. Workplace sexual harassment can include asking questions, talking, or writing about sexual activities. It could be rough or vulgar humor or language related to sexuality, sexual orientation, or gender. Displaying or circulating pornography, sexual images, or offensive sexual jokes in print or electronic form. Leering, invading a person's personal space, unnecessary physical contact, including inappropriate touching, demanding hugs, dates, or sexual favors, making gender-related comments about someone's physical characteristics, mannerisms, or conformity to sex role stereotypes, verbally abusing, threatening, or taunting someone based on gender or sexual orientation, or threatening to penalize or otherwise punish a worker if they refuse a sexual advance. One of the things you do want to be very cognizant of is if you have a complaint of sexual harassment in the workplace and it's one of your employees working at a customer site, there may be situations where it actually breaks the criminal code. You would want to take a look at some of these sexual harassment. You may need to report it to the police. It may not just be an occupational health and safety matter. It may be a criminal code has been violated, and you may need to consider working with the police and informing them of certain events that may happen. Workplace violence is the exercise of physical force by a person against a worker in a workplace that causes or could cause physical injury to the worker. So it doesn't necessarily mean I punch someone and they get hurt. It could mean the possibility that what I do could get that person hurt. Could be an attempt to exercise physical force against a worker in a workplace that could cause physical injury to the worker. And lastly, it could include a statement or behavior that is reasonable for a worker to interpret as a threat to exercise physical force. So, for example, after work, I'm going to meet you in the parking lot and I'm going to punch you. All those things can be considered workplace violence. What sort of things do these can include? They could be verbally threatening to attack a worker. So, in my example, I'm going to punch you after work. That it would be listed as workplace violence, very much so. Leaving threatening notes or sending threatening emails to a workplace, shaking a fist in a worker's face, wielding a weapon at work, hitting or trying to hit a worker, throwing an object at a worker, sexual violence against a worker, kicking an object the worker is standing on, such as a ladder, or trying to run down a worker using a vehicle or equipment such as a forklift. Hmm. So workplace violence is obviously, again, you could be, depending on what has happened, you may need to get police involved if it's serious enough. Harassment, violence in the workplace, completely unacceptable. In the case of workplace harassment, there are very specific things you need to do. So different legislation has dictated if you're in Ontario, you have to perform an investigation and then you have to inform the person who made the complaint of what happened in that investigation. Those are very specific things. It doesn't matter that you're a third party supplier of the labor. We are still required to perform the essential requirements of the Occupational Health and Safety Act, even as temporary employment agency providers of labor. We're going to switch gears, take a look at hazardous sound levels. So OELs, occupational exposure limits, are typically given as the maximum duration of exposure permitted for various noise levels. So how long have you been exposed to a sound? In Ontario, we listed as 85 decibels for an 8-hour shift as the OEL. We also have different gradations of it. So they do make a provision that you can be allowed for 15 minutes in a shift, that the noise can go up to 105 decibels. There are various limits, and the protection is based on the exposure, how long you were exposed and how loud the exposure was. So that's the criterion, the steady noise level permitted for a full 8-hour work shift. So that's the overall workplace, the hum, the noise of it. Depending on the workplace, you would want to ensure that it's not breaching that 85 level. Exchange rate, which means the amount by which the permitted sound level may increase if the exposure time is halved. So again, that's talking about a louder sound, but less time. How long can you be exposed to that? Every jurisdiction has specific time limits or specific limits set out. Uh, we're kind of aligning with them. Some of the provinces are coming to it. The problem is it gets pretty technical. You need specialized equipment. You need someone that has deep experience in that. And it's not something that we generally would see or be involved with. That would be the customer typically involved with it. What it means though is if you understand that there are specific requirements, like wearing hearing protection, such as these earmuffs in the picture, you want to do it for specific reasons. And you got to understand that if it is required in the workplace, if it's required for full-time employees, it's going to be required for part-time employees as well as temporary employees. The idea is you want to protect workers, so you want to take all measures reasonable to protect the workers from hazardous sound levels. There's called hierarchy of controls, so there's engineering controls. There's specific things that you can do to limit the noise level, such as wearing PPE. You want to implement the controls, post warning signs, and provide training so that all employees are aware of the hazards in the workplace. And take a look at first aid requirements. First aid requirements are unfortunately different in every province. There is some work to align all the provinces together. Any of you that do operate in different provinces, be aware of it. If you order a first aid kit in Ontario, it is going to be different than it is in BC. You just have to be aware of it and make sure you are following the province of the workplace and their first aid requirements. Hopefully very soon. They're very slow at adopting it. Other provinces are quite slow in trying to amalgamate and provide the same sort of first aid requirements. These specific things are Ontario. They discuss the requirements of the first aid. So the first aid equipment and services, they have to be inspected quarterly. So you have to take a look at your first aid box, even in your office. You should be having one, depending on the size and so forth. You should be inspecting those quarterly. First aid stations must be easily accessible or near a worker has a valid first aid certificate from WSIB. Very important. You need to make sure that everyone has, or every workplace has a first aid trained person through all shifts. That's an important thing for your offices as well as when you're doing your client inspections. Notice boards displaying first aid posters, first aid certificates, the valid first aid certificates of qualified trained workers on duty, and a kit inspection available card is available. And there must be detailed records of all incidents and first aid treatment given. So if someone cuts themselves and requires first aid treatment, there has to be some sort of log in this. What happened? What time was it? Who was involved? Type of thing. Draw your attention to this. This is the Ontario rules. The training required for workplaces with six or more workers on any shift is a standard first aid certificate. That's just the name of the type of training. Again, every province is different, and it will be dependent on the size of the workplace themselves. First aid stations are under the care of a worker with a valid first aid certificate. So that means there needs to be one first aid person at least on every shift. There should be a first aid trained person within each area. And they typically designate it as within a 2-minute walk. So the first aid kit can't be on the complete other side of the warehouse. And CPR is a mandatory module as part of the first aid training program. Taking a look at OSA and critical injury, switching gears again. Critical injury is defined as an injury that is serious in nature and does the following. Places a life in jeopardy, produces unconsciousness, results in substantial loss of blood, results the fracture of a leg or arm but not a finger or toe, involves the amputation of a leg or arm, hand or foot but not a finger or toe, consists of burns to a major portion of the body, and causes the loss of sight in an eye. There are very specific things to do if any of those conditions occur. This is Ontario definition, but every province is going to have something quite similar to this. In Ontario, if a critical injury occurs, the employer must notify the Ministry of Labor inspector immediately by phone. They must contact a member of the Joint Health and Safety Committee or the whole health and safety rep, and there must be an investigation, and a written report must go to the Ministry of Labor within 48 hours. So you got some things you have to do if there's a critical injury. First, if the critical injury occurs at your client, you are going to want to communicate with that client and find out who's going to report the critical injury to the Ministry of Labor. Is it the client or is it going to be us? Then you have to ensure that your investigation is complete. The Ministry of Labor, once you inform them of the critical injury, they are going to decide whether they send an inspector or not, whether they're going to just do a telephone investigation. Depends on how serious it was and whatever criteria they have. And lastly, within 48 hours, you have to send in a written report to the Ministry of Labor. And that's defined in the legislation. It tells you exactly what you need to report. But it has to be in writing, sent in, via fax or email or so forth, to the director at the Ministry of Labor. Again, other provinces have similar sort of rules, but Ontario defines it like this. So we said this: when you report a critical injury, immediately you have to phone it in, and then within 2 days, 48 hours, you have to send in the written report. We're going to take a look at this case study. So a new client, places an order for general labor. It is the final assembly line that wraps in boxes of cans of cat food. They will then lift the new package and put it on a skid. Another worker will use a forklift to pick up the skid when it is full. The customer tells you that they run a very safe operation and have won a safety award. Training will be provided around their safety procedures. Safety boots are required and gloves will be provided. After the second week, the employer placed at the assignment tells you they will not return. The reasons they provide is the equipment that is used to put plastic wrap on the case of food is blocked, and they want you to push the product through with your hand using more force. They've also asked that in the absence of the forklift driver, you operate the forklift and move the skids to a designated area. You refused, but the supervisor said everyone does it. Lastly, you burned yourself while packaging and your supervisor told you to be more careful. You do not feel safe and the supervisor intimidates you. So just a quick true or false. You and or the customer can discipline your employee for refusing to work. True or false? So if you remember back to one of the first slides of the conversation today, we discussed the basic rights of every single worker. And one of those responsibilities or one of those capabilities is the right to refuse unsafe work. So can you discipline the employee for refusing to work? No, you cannot. So that is false. You are prohibited from penalizing, dismissing, disciplining, suspending, or threatening to do any of these things for a worker who has refused to work. Ultimately, they are following their basic rights and the rules and regulations of the Occupational Health and Safety Act. So an employee can refuse work at any time for the following reasons. The physical condition of the workplace or the workstation is likely to endanger your employee. Any machine, equipment, or tool that the worker is using or the physical condition of the workplace is likely to endanger your employee or another worker. Lastly, workplace violence is present and is likely to endanger your employee. True or false? The employee will not be paid while refusing to work. So will the employee will not be paid while refusing to work? True or false? So the answer to this one is false. There are a couple stages. There's three stages involved with this, with a work refusal. An employee will be paid during the first stage of work refusal. I'll discuss what these means in a moment, but they will be paid. Taking a look at the stages of work refusal. We have what's called stage one. And this is the stage where the employee comes to the supervisor who is working at a machine, let's say, and says, I don't feel safe on the machine. It's squirting oil on the ground. I feel I'm going to slip and trip and hurt myself. In this case, the employee is stating his or her basic right to refuse unsafe work. The worker must stop working immediately and inform the direct supervisor. Supervisor will investigate. The worker must remain close to the site. So you can't send the worker home. Even if it's a temporary employee, the client just can't send them home. There will be repercussions if it goes further past this stage. Upon resolution, the worker must report the incident in the branch within 24 hours. Um, this stage is hopefully where most of these work refusals are rectified. They're fixed. So the employee says this is unsafe. Supervisor or management comes and says, you know what, I agree with you. There's a leaking hose and it's leaking oil on the ground. We're going to fix this. And then the worker it gets fixed, gets rectified, and then the worker returns to the work site. The employee in these cases who is refusing work must remain in a safe place. So it doesn't necessarily mean right there at the machine, but a safe place near the work station, as long as that's reasonable until the investigation is completed. This is known as the first stage of work refusal. If the situation is resolved at this point, the worker will return to work. Many times the investigation is concluded. As I said earlier, the situation is rectified and the worker can go back to work immediately. However, if it's not, if there is any sort of dispute, so if the worker says this is unsafe, supervisor comes in and says, no, it's perfectly safe, and you are at a standstill, and the supervisor says return to work, you proceed to what's called stage two. If the worker has reasonable grounds to continue to believing that the site or situation is still unsafe, they would proceed into two. They would continue to refuse to work on the grounds. At this point, you're going to swiftly move into stage three. Stage three is where you do not want to be. Stage three is where you involve the government. You would call the labor inspector. in this case in Ontario, the Ministry of Labor, provincial inspector. And the inspector will receive the report and they will either come to the workplace or they will do it over the phone. They will investigate in some manner and then they will issue a decision. Decision is going to be in writing. It's going to conclude that the work is safe or not safe. If it's not safe, they will say make it safe. They will not say fix it. They will generally not say fix this and that and do all those things. That is for the employer to make it right. The inspector must decide whether the work is likely to endanger the worker or other persons. And the inspector, when they are on the work site, they may take their time and look at other aspects of the work site. This is why I said in stage one, sorry, you want to rectify the situation. You want to ensure that you do not make it into stage three. Because as soon as you involve calling the Ministry of Labor, again, they have free reign and they are allowed by law, the Occupational Health and Safety Act, to inspect that workplace. They may not just look at that machine. They may inspect your entire client workplace. So it is very important when you do have these situations, A, you're documenting it. If the employee does have a work refusal, you need to understand and you need to train your people inside your offices. If a temporary employee has a work refusal, there are steps you need to take. It's even more important because we're not necessarily on site. If you have a work refusal, you probably want to communicate pretty quickly with your client and figure out what's going on. And all these things, again, proper training needs to happen in your workplace so you understand that the temporary labor you're sending to third party, to the clients, when there is a work refusal, A, that they know they're allowed to refuse work, and B, that if there is a work refusal, you're following the proper precautions required by law. I'm going to start looking at the last part, Provincial Compensation Act. Depending on what province you're in Ontario, it's WSIB, other provinces is WCB, WorkSafe, Workplace NL. It depends on what provinces you're actually in. Employees, managers, supervisors, workers, and the government all have responsibilities when it comes to workplace health and safety, which we have discussed. We're going to be looking at what happens when things break down and someone is injured at work. So taking a look at the specific definitions from Ontario, it's the purpose of the Workplace Safety and Insurance Act. What the Workplace Safety and Insurance Act or Workers' Compensation Act or whatever it is listed in your province, what it is an insurance plan to compensate employees who are injured or disabled due to workplace accidents. Its purpose is to ensure whenever possible, the employees return to the work of the pre-injury after the injury themselves or the occupational disease. They're generally tasked with promoting health and safety in the workplace and overall reducing injuries and disease. And they help facilitate the return of work and recovery of workers. Workplace Safety and Insurance Act is, it was born out of the early 1900s, very early 1900s. And it has a few components that are shared across all the provinces and all the territories. It is what's called a no-fault system. It does not assign fault. So when there's an accident in the workplace, its job generally is not to go in and say, Mr. or Mrs. Employee, you're at fault for this. You're going to be fined more or not. It is to supply the workers with recovery opportunities, recovery monies if they are losing money. It is funded 100% by employers. What does that mean? It means it's not part of the general tax base. So employers pay a premium, depending on the size of it, depending on province. Every month you're going to report your earnings for depending on what province, but if it's like a rate class that we have in Ontario, you're going to say, I had $100,000 of earnings in this particular rate class. You're going to have an amount of money you have to pay for it, and you will send WSIB a check every month or every quarter or once a year, depending on your size. Many people think it's part of the general tax basis. It's not. It's 100% funded by employers. There are very strong financial and legal implications associated with that. If you are an employer and you do not follow the rules and regulations of the Workplace Safety Insurance Act, you can be fined. You can face an administrative monetary penalty. You can face other judgments by the workers' compensation, such as reinstating a worker. And that applies equally to us. We are the employer of record in every province, territory for the workers that we supply to clients. So we have to be very cognizant of workers' compensation, the rules, penalties, and so forth as you're doing business in these different markets. So when an employee is injured at work or contracts an occupational disease in the course of employment, the Act says the employee needs to receive support and health care by way of a number of things. They have to return to work in his or her pre-injury position or other suitable work. That's very important for us. It doesn't necessarily mean that the employee has to return to client A. So if they're hurt at client A, you don't necessarily have to put them back at client A. You could potentially put them back at client B. Maybe client B has less physicality or they're able to do that work. They may provide assistance in finding alternate employment. Again, that's what I just discussed. However, what happens if you cannot come up with an accommodating system, the board may put them into retraining and putting them into a whole other type of work. You generally don't want to get involved with that because it's going to be very costly. Lastly, it also enables compensation to be paid to the worker when a worker loses earnings or becomes disabled to a workplace injury. So essentially, the worker is going to receive healthcare. They're going to receive support to get back into the workplace, and they're going to receive compensation so that they're made whole, so that they're not going to lose their house and their car and become financially destitute from a workplace injury. What do you do when there is an injury? Record keeping is critical. And we say that as an employer, you must keep a record of all accidents as described by the injured worker, regardless of whether or not he or she received healthcare. So you're going to want it to have some basic information. I always call it the who, what, where, when, and whys. If you are investigating an incident or an injury, you want to get those things. You want to know what the date and time of accident was. Any witnesses, you want to acquire that information immediately. In 2 weeks' time, you may not have the same access to information. What's the nature of the injury? What's the location of the injury? What's the details of any first aid treatment given? I have a saying that if it's not documented, it didn't happen. So in the case of government, in the case of workers' compensation, and you're doing an investigation into someone that was injured, you want to make sure it's documented. You don't want to just have word of mouth conversation about that. The government will not accept that information. If you have a formalized process of investigation where you have a form of some sorts and you investigate the first aid injury or the workplace injury or the whatever has happened, and it's documented and signed and there's a record of the information. That's what I mean by if it's not documented, it didn't happen. There's a clear difference between that. Even if it doesn't seem serious, sometimes if someone, it's just a first aid injury, someone cut their finger, oftentimes you want to, even if you don't necessarily feel you need to, it's important sometimes to keep a record of that. Sometimes what happens is someone injures themselves initially, and it doesn't actually have an effect on them until a little bit later. Maybe they cut their finger and that finger cut becomes infected in the workplace. What you have is a first aid only injury that's transitioned into an injury that must be reported to the government. So when there is a critical injury in the workplace, the manager is required to report the injury within 20 to 36 hours of the injury taking place to the safety group, 3 days to workers' compensation, immediately to the Ministry of Labor, 2 days with a written report to the Ministry of Labor, all the above, or B, C, and D. So the best answer here is F. So we remember, or we know that we have to report any injury to workers' compensation. Critical injury, we have to immediately to the Ministry of Labor. And then we must remember within 48 hours, 2 days, we have to send in a written report to the director at the Ministry of Labor. Reporting accidents. So if an employee is absent from work and or receives healthcare as a result of a workplace accident, incident must be reported to the WCB within 3 days if your worker loses time from work, earns less than a regular day pay, or gets outside health treatment. If you remember nothing else about workers' compensation and injuries, remember this. If the worker goes to any sort of healthcare or misses time from work over and above the day of the injury, you must report it to the workers' compensation system, WSIB here in Ontario. So you don't necessarily have to report the injury if it is just a first aid injury. So if one of those two criteria aren't met, didn't have to go to healthcare, didn't miss any time from work, that would just be what's known as a first aid only injury. You want to have record of it, so you want to have some sort of report within the system. You don't have to report it to the government though. Return to work and duty to modify work. When considering modified work, consider how it will support the injured worker. So the general acronyms, it has to be achievable, safe, constructive, and productive. So what this means, what is return to work or modified work? If the worker hurts themselves and they're unable to do the essential tasks of that job, you have to bring them back as best you can without undue hardship to work that is they're able to do, to work that is achievable, safe, constructive, productive. So what achievable means is when work is achievable, we help to provide confidence to workers as well as ensuring the work is achievable based on the worker's injury and any limitations. So you have to take a look at in concert with safe. So we want to continue to keep all the workers safe. So this is a key component when workers are returning. So you want to be looking at things like medical. So you have some sort of an FAF form or looking at the Form 7 and seeing what the medical limitations of that person are. You don't want to be asking them to do work where they're going to injure themselves further, whether it's the initial injury or, a secondary component of the injury itself. You aggravate you hurt your knee, you aggravate your other knee because you're walking weird. You have to make sure it's constructive. So are you able to continue increasing the skill level of your worker? And you have to make sure it's productive. We all want to be productive and contribute to the overall success of an organization. What this means is modified work is not having the employee sit in the lunchroom watching Netflix all day. If there is a complaint made by the employee to the workers' compensation, they would view that work as not suitable, not productive, not actually doing anything for the betterment of the company. They may fine you in that case, or they may, tell you to modify the work different. That sort of thing you have to keep in mind if you are performing any sort of return to work functions in the workplace. We're gonna skip that part. I don't think there's any Alberta, so we will skip this area. What we have here, and this is part of the handouts that were sent today, we have some links for learners. This is where you would acquire the information. So we have the Provincial Compensation Boards of Canada are listed here. Whether you follow the link or just do a quick search, even if you're not necessarily, say, doing business in, let's say, British Columbia. British Columbia has a really good site with some information that you could use for general safety information, whether you're just in British Columbia or not. So it pays sometimes to take a look at these sites, like look at them and see if there's any benefits. Just understand the rules and regulations are going to be only um, respectful of what province you're operating in and where the worker was injured. But definitely some of these other workers' compensation boards are really important to take a look at. A couple of resources. We have the Canadian Center for Occupational Safety and Health. Very good information. If you're looking for safety information for your, like, say, job descriptions, if you're creating them for your temporary workers, it's a great resource. I believe it's federally funded. So it's free, and most of it's free. And you're able to get some really good answers with respect to generalized health and safety in the workplace. You can look at your Ministry of Labor's within your own jurisdiction. So if you're in Ontario, the MOLITDS is a very good one as well. The other one that's not listed here, if you're looking for any sort of workers' compensation like rulings or the actual legislation or regulations for any of the provinces or federally, CANLI is one that I use often, CANLII. Uh, Really important one for that. Um, Sorry, the Quebec one is not working. They may have changed their URL. If you look up CNESST, just Google that, Pauline, in the answer queue. CNESST, they'll be able to provide you information obviously for Quebec. So, any questions? Okay, so that concludes the module today. Again, I recognize very, very dense with information. Um, we did make sure that any information you need to write your CPC is contained in the presentation itself. So there's no trickery to it. It is contained in the documents provided. I wish everyone luck if you're writing it. I certainly hope that you do write the CPC. Oh, we do have a question actually, sorry. The question is it appropriate to ask a job candidate about food allergies during the hiring process? Would the question serve a legitimate purpose, or could it cross legal boundaries or come across as discriminatory? Um, Generally, we don't want to offer legal advice. I will, I don't want to completely skirt your question. I would say that you would probably want to seek legal advice on that if you are doing it. Only because you brought up a good point. It could bump into being discriminatory practice. So you could face a human rights issue. That's kind of beyond what Access would provide to you. You may want to, again, get some outside legal advice specific to that. I would say though that you have to be very cautious about asking about those things. Hopefully that answers your question. Very good. Okay, good luck everyone. Thanks for your time and